morning. A quorum being present, the subcommittee will come to order. We welcome you today. This is a real live subcommittee hearing, but it sure feels much better in a way being back in my district with a field hearing. I'd like to thank our witnesses for joining us. I'd also like to thank the staff here at the Lansing Community College for their hospitality. This is a great facility. It kind of evidences what Education and Workforce Committee is all about in addressing real-world needs for real-world working environment, as well as people trained and prepared for real-world jobs. And living around Washington at times, real world is not the expression we all know all that much about. So it's good to get out here. It's good to be here and have the opportunity to learn more about how policies and proposals coming out of Washington are affecting workers and employers both in Michigan and across the country. Discussions like this are important because they inform the work we do as lawmakers. They help us, as your representatives in our nation's capital, better understand your concerns, your struggles, and your successes. And they help us ensure your priorities remain our priorities. I don't have to tell you that in this economy, which is still struggling to recover, a lot of Americans continue to face significant challenges. Millions of men and women are struggling to find jobs. Millions of others are working part-time jobs when what they really need and want is full-time work. Family incomes across the country remain flat. People are hurting, and as policymakers, we have a responsibility to do everything we can to help. One important way we can do that is by taking a close look at the rules and regulations governing our workplace. For almost 80 years, the Fair Labor Standards Act has been the foundation of our wage and hour standards. 80 years. The law plays an important role in the lives of millions of working Americans. The problem is that a lot has changed in our workplace over the last 80 years. We've even gone beyond bag phones. And the federal wage and hour rules have not kept up. Today, the regulations guiding the laws implementing are rigid, outdated, and simply not working for the 21st century workforce. Millennials are now the majority of the workforce, and they, like most in the workforce, do not want a flawed regulatory structure that constrains flexibility and innovation by creating confusion and uncertainty in today's workplaces. Unfortunately, the current law raises more questions than it provides answers. That's why Republicans have long supported improving and updating the rules surrounding federal wage and hour standards, modernizing them to account for advances in technology and to better reflect the innovative, flexible economy we have today. We remain willing and ready to work toward that goal. However, we also remain insistent that we do so responsibly. It's not enough to simply change the rules. We have to improve them. And we have to do so in a way that does not place additional burdensome requirements on small business owners, does not stifle job creation and wages, and does not limit opportunity and flexibility for workers. Unfortunately, the administration is taking a different approach to updating workplace rules and regulations. In fact, the Department of Labor is in the process of finalizing an overtime rule that is anything but responsible. Instead of making changes to address the complexity of current regulations, the proposal will impose significant burdens on the employers, limit workplace flexibility, and make it harder for workers to advance in their careers. The administration's regulatory proposal will ultimately hurt the very people we need to help. There are better ways to update and modernize current rules and regulations, and we owe it to the American people to explore them. That's the purpose of today's hearing. We want to hear about your experiences and understand your concerns. What's working? What's not working? What changes need to be made to ensure federal policies support rather than discourage the economic growth our nation desperately needs? How can we help you and others in our communities pursue the personal opportunity you're working to achieve? I look forward to hearing from each of you on the panel, so I'm going to yield to my distinguished colleague from Michigan, Congressman Mike Bishop, for his opening remarks as well.
Thank you, Chairman Walberg, and thank you to our panel for being here today. I want to make a special acknowledgement to Chairman Walberg for his dedication to this cause and for his steadfast leadership on this committee to address this issue. I want to thank you for being here, everybody, for participating in this hearing. These discussions are very helpful to all of us, very valuable. They help us deliver meaningful solutions to the many challenges facing Americans right now, including those facing our workers and job creators. In fact, when it comes to updating rules and regulations related to workforce protections and wage and hour standards, having the opportunity to hear your perspective and experiences are particularly important. Because when we're talking about these issues, it's not about public policy. It's very personal. It's personal for the workers who need the flexibility to care for their loved one. It's personal for the parent who wants to make it to their child's school or game, and I can relate completely with that. It's personal for the working mom or dad who is helping an aging relative. Workplace flexibility is incredibly personal and important to a lot of people. It's also personal for the low-wage worker trying to seize opportunities to move up the economic ladder. At a committee hearing last year, we heard from a witness, Eric Williams, who worked his way up from crew member at a fast food restaurant to become the chief operating officer of a major U.S. corporation. On top of that, he also owns and operates several restaurants of his own. This is the American dream. It's also what's at stake if we miss the mark when it comes to updating regulations related to work, wage, and hour standards. As Chairman Walberg did say, the rules and regulations guiding implementation of the Fair Standards Act are too complex. They're burdensome and they're outdated. They no longer provide the kind of protections and opportunities that they could and should for workers and employers. I think that's something Republicans and Democrats can clearly agree upon. Where we disagree, seemingly, is the best way to update them. During the same hearing in which Eric Williams shared his inspiring success story, he also raised some troubling concerns with the consequences one of the administration's recent regulatory proposals had, and that was the Department of Labor's overtime rule, which the good chairman shared a little bit of his concern about earlier. It will create for workers and small businesses significant concerns, despite the fact it was intended to help. Mr. Williams explained that the rule will be detrimental to workplace flexibility, how it will negatively impact pay and bonuses, and how it will severely limit hardworking, talented Americans from recognizing and realizing their dreams. Workers and small businesses are not the only ones concerned about the administration's proposal. Those in higher education worry the rule could have unintended consequences for them as well, leading to higher costs and forcing schools to restrict hours for certain employees. Here in Michigan, we're very fortunate to have an abundance of incredible universities that serve students from our state and from our states across the country. Two of our witnesses are joining us from some of them, the University of Michigan and Michigan State University. Under no circumstances should we be making it harder and more costly for students at these universities or any university to receive a quality education. Americans deserve better than the changes that led these kinds of consequences. That's why we will continue our efforts to promote and encourage reforms that clarify current rules and regulations, modernize them, and make them better. Reforms that won't stifle innovation, flexibility, and opportunity. These things are essential in allowing our workforce to grow and change to better meet the needs of workers, job creators, and consumers. And they will continue to help us push the limits of what we are able to accomplish. I look forward to hearing from all of you, all of your comments, and look forward to working with all of you along the way as we accomplish our goals. Thank you. Yield back.
I thank the gentleman. Pursuant to Committee Rule 7C, all committee members will be permitted to submit written statements to be included in the permanent hearing record. And without objection, the hearing record will remain open for 14 days to allow statements, questions for the record, and other extraneous material referenced during the hearing to be submitted in the official hearing record. It's now my pleasure to introduce today's witnesses. Ms. Nancy McKee is Senior Vice President of Employer and Community Strategies and Chief Human Resources Officer for the Michigan Health and Hospital Association, and is testifying on behalf of the Society for Human Resource Management. She is responsible for internal human resources and is a staff lead for the Michigan Health and Hospital Association's Business Advisory Council, and not a stranger to this subcommittee in hearing process before. Welcome.
Thank you.
Mr. Jared Meyer is a fellow with Economics 21 at the Manhattan Institute. He conducts research in microeconomic theory and the effects of government regulation and is kept busy doing that. Welcome. Dr. Dale Bellman is a professor with the School of Labor and Industrial Relations and adjunct professor with the Department of Economics at Michigan State University. Much of his work has focused on collective bargaining, labor relations, and compensation in the public sector and government regulation of labor markets. Welcome. Ms. Lorita Thomas is the Associate Vice President for Human Resources at the University of Michigan. And we have no wall in between these two schools right here. It's not football game day. And a handshake. In this capacity, she is responsible for human resource policy for all University of Michigan campuses and a full range of comprehensive integrated human resource services, products, and operations. A full plate. Welcome. Mr. Mark Wilson is Vice President and Chief Economist for the HR Policy Association. He previously served as Deputy Assistant Secretary for the Employment Standards Administration at the Department of Labor. His work has focused on providing research and analysis of employment impacts and costs of workplace-related litigation and regulations, and is no stranger to this committee as well, and also to this area, since this is your home area.
Yeah.
You grew up in East Lansing. Welcome back. I'll now ask our witnesses to stand and raise your right hand, as is the process in this committee. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated. Let the record reflect the witnesses answered in the affirmative. Before I recognize you to provide your testimony, let me briefly explain our lighting system. And I'm looking for, oh, there it is. Here's our lighting system. It's fairly self-explanatory. If you know the stoplights on the roadway, it's pretty much the same. With the green light on, you have 5 minutes of testimony. When you see the yellow light come on, that means that there's a minute left in those 5 minutes. And then when red, finish up your sentence or short paragraph to the best of your ability. In a field hearing like this, with the amount of time that we do have and the limited number of members of the committee here, we're not going to hold with great strictness to that. But we'd appreciate, because we will have opportunity to ask questions relative to your testimony. And so let me recognize our witnesses now, beginning with Ms. McKee for your 5 minutes of testimony.
Thank you. I am Nancy McKee. I'm Senior Vice President and Chief of Staff for the Michigan Health and Hospital Association, and I am appearing before you today on behalf of the Society for Human Resource Management. Thank you for the opportunity to testify before the subcommittee again, at this time in our home state, on how federal regulations affect innovation and flexibility in the workplace. As you mentioned, Mr. Chairman, few regulations impact the workplace more than those that implement the Fair Labor Standards Act. While employers of all sizes work diligently to classify employees correctly and remain in compliance with the FLSA, classification decisions are particularly challenging because they're based on both objective and subjective criteria. Therefore, on occasion, an employer acting in good faith could mistakenly misclassify employees as exempt, who in reality should be non-exempt, or vice versa. Let me tell you a little bit about the MHA. We're a nonprofit association, and we advocate for hospitals and the patients and communities they serve. We're an employer of choice, having received several workplace awards, which are referenced in my written statement. Yet even some of the best employers face practical challenges with the FLSA. It's not uncommon for employers to face high legal costs for complying with the statute, costs that are particularly difficult for an organization like the MHA with a tight budget. Unfortunately, increased litigation related to alleged FLSA violations leads to less funding for the nonprofit's core mission, whether that's providing patient treatment, caring for children, or conducting research. Nonprofits like MHA must make challenging employee classification determinations because our employees are often performing a mix of duties, which includes both exempt and non-exempt functions. For example, sometimes we'll find that one of our employees will fit all of the executive employee exemptions under the FLSA, with the exception of supervision of 2 or more employees. Take the instance of our MHA Foundation. The executive director for the foundation supervises only 1 employee. So that made our determination of her status a little bit more challenging. But in the end, we determined that she should be classified as exempt because of her autonomy, her experience, and our confidence in her judgment. Given those sorts of ambiguity, the stakes in improperly classifying employees are high. Planning for an increase in litigation can be particularly difficult for the nonprofit sector and small employers. When the 2004 changes to the Fair Labor Standards Act overtime regulations were enacted, the MHA had to allocate additional funding to retain counsel in order to assure our practices were compliant. In the end, a nonprofit hospital's decision to direct limited funding to defending against lawsuits means less money for patient care and treatment. As an employer in the healthcare sector, our member hospitals are working 24 hours a day, 7 days a week, providing critical treatment and care to patients. Because of the nature of our work, we must have the ability to respond as quickly as possible and utilize flexible hours, especially for clinicians. The FLSA makes this difficult for certain employees. While non-exempt employees can receive time and a half pay, they can't be afforded the same workplace flexibility benefits as exempt employees. The FLSA actually impedes workplace flexibility by prohibiting private sector employers from offering non-exempt employees the option of paid time off rather than overtime pay for hours worked over 40 per week, even though all public sector employees are offered this type of flexibility, which is commonly referred to as comp time. SHRM has long supported the Working Families Flexibility Act to provide employees with the option of comp time to business and their hourly employees. Mr. Chairman, today's examination of the FLSA is particularly timely given the administration's overtime proposal is under final review after they received more than 290,000 comment letters in response to the proposal. SHRM has repeatedly stated that an increase to the salary threshold for overtime pay is warranted, but the DOL's proposed 113% increase is too much, too fast. Using a salary threshold at the 40th percentile of average weekly earnings, which is estimated to be more than $50,000 for 2016, presents significant challenges for small employers, nonprofits, and employees in lower cost of living areas. If the salary threshold is doubled, many employees will lose their exempt status and the workplace flexibility it affords, not to mention the professional status and autonomy that go with it. Mr. Chairman, thank you for introducing the Protecting Workplace Advancement and Opportunity Act, which would nullify the DOL's overtime proposal. SHRM strongly supports this legislation to require the department to conduct an economic analysis of how changes to the overtime rules will impact nonprofits, small business, and others before they issue a new rule. This is a reasonable response to the current overtime proposal, and SHRM encourages all members of Congress to support it. In closing, SHRM and its members are committed to working with the members of this committee to address the FLSA in a manner that balances the needs of both employees and employers and does not produce requirements that could limit workplace flexibility. Thank you, Mr. Chairman.
Thank you. Now I recognize Mr. Meyer, and it's good to have a millennial on our witness panel here to hear perspective. You have 5 minutes.
Well, Chairman Wahlberg and Representative Bishop, thank you for the opportunity to give testimony on how new administrative interpretations of the Fair Labor Standards Act of 1938 fail to reflect the realities of today's workforce. I'm a fellow at the Manhattan Institute and am the co-author with Diana Furchtgott-Roth of Disinherited, How Washington's Betraying America's Young. I'm also the author of the forthcoming Uber Positive, Why Americans Love the Sharing Economy. The American economy is changing, and millennials' attitudes about work and their careers are changing with it. The rapid rise of the so-called sharing economy embodies many young Americans' new economic ideal, one driven by technology, convenience, and flexibility. Companies such as Uber and Airbnb offer the technical platform and support to allow transactions between buyers and sellers to easily take place. For this reason, these types of companies are referred to as intermediaries. Those who partner with intermediaries are classified as independent contractors, not employees. The flexibility that independent contractor status offers workers is vital to the success of the sharing economy. While some workers use these platforms full-time, the vast majority use them for part-time work and supplemental income. About 8 in 10 Lyft drivers work under 15 hours a week, and over half of Uber drivers use the platform for less than 10 hours a week. Furthermore, half of Lyft drivers work another job while partnering with the company, and 2/3 of Uber drivers work another job as well. Independent contractor status allows the decision of when and for how long to work to be controlled by workers, not companies. And this opportunity to smooth out earnings to do everything from meeting rent to paying down student loans or funding a new business venture is a benefit of the sharing economy that must be protected. This is especially critical for the 70% of Americans ages 18 to 24 who experience an average monthly change of over 30% in their monthly incomes. But the sharing economy's rise obscures a troubling economic trend. Once dynamic, the American economy is growing slowly, and entrepreneurship is actually falling. Even though 2/3 of millennials want to work for themselves at some point, less than 4% of private businesses are even partially owned by someone under the age of 30. One reason for this is government policy, particularly in regards to labor regulation, ignores the realities of a 21st century economy and continues to hold back millennials' economic opportunity. For example, the Labor Department recently issued an administrator's interpretation, effective immediately, to clarify the definition of independent contractors. It states, most workers are employees, not independent contractors. Because it was termed guidance, it didn't even have to go before the public for comment, even though it has the potential to upend the sharing economy. Currently, workers are either classified as employees or independent contractors. Employees are given many protections and benefits under the Fair Labor Standards Act that are not available to contractors. In exchange, employers are able to set the terms of workers' employment. On the other hand, the independent contractor status provides workers with more control and flexibility. The Labor Department's new interpretation formally accepts the 6-part economic realities test for determining whether workers are employees or independent contractors. At the same time, it downplays one of these 6 criteria, a lack of control over workers' hours, as a determinant in employment status. This could be devastating for sharing economy companies as they do not control their workers' hours. Unlike employees, independent contractors are not entitled to minimum wage, overtime pay, unemployment insurance, or workers' compensation. But extending these employment protections to independent contractors makes no sense. When debating the future of worker classification, lawmakers should resist calls to extend employee wage and hour protection to independent contractors. Since intermediaries, again referring to sharing economy companies, do not control workers' hours, and determining how much someone is actually working only for that intermediary is very difficult, if not impossible, minimum wage and overtime pay requirements are inapplicable to these companies' business models. Additionally, One of the benefits of the sharing economy is that supply can easily fluctuate to meet an ever-changing demand. Because of the option of flexibility, independent contractor work for intermediaries is often transient or done in addition to other work. Think back to the statistics I used earlier. This is why there is little reason to compel employers to fund unemployment insurance benefits. Intermediaries workers are also usually completing jobs off-site and using their own materials. For these reasons, workers' compensation systems should remain optional, not made mandatory for intermediaries. But most importantly, the worker classification question needs to be sorted out by federal legislators, not courts or unaccountable executive agencies. The alternative is the crippling of the sharing economy by executive agencies that are set on incorrectly classifying the vast majority of new economy workers as employees. Millennials want to be entrepreneurs, and they desire employment that is flexible, mobile, and individualized. The Department of Labor's attempts to stifle the rise of the promising new business models seen in the sharing economy through regulation is in no way to help millennials achieve their vision of the American dream. In order to promote an entrepreneurial workforce, Congress needs to use its power to rein in the Department of Labor. Thank you again for the opportunity, and I look forward to continuing the discussion.
Thank you. Dr. Bellman, I recognize you for your 5 minutes.
50, 40, maybe as close as 30 years ago, there was broad agreement that the U.S. economy was based on shared prosperity. Firms prospered. Employees and employers worked together, learned how to do work better, increased productivity. They shared those gains, not equally, but they shared in the gains from doing things better, from improved prosperity. This resulted in better pay, better benefits, improved economic security, investments in employees and in employee training. For example, George Romney, president of American Motors in the late 50s and early 60s, both limited the pay to top managers and instituted profit sharing, first of the auto companies to do that. Even major retailers such as Sears prided themselves on good salaries and benefits and a career path for diligent employees. Sears, of course, was non-union. A belief in shared prosperity was also expressed in the implementation of protective labor legislation. The Fair Labor Standards Act was extended to cover wholesale and retail trade, to cover hospitals and the public sector. We improved the security of private pension plans through ERISA. Under the Nixon administration, we created OSHA to create a safer and more healthful workplace. This path to shared prosperity has significantly been abandoned for one much more of a winner-take-all economy, one that too often pits employers against employees. We can see this in stagnant real wages over the last 35 years. Only slow improvement in family incomes, and that only because families are working more hours, largely by moving women into the labor force. Likewise, levels of income and wealth inequality have risen to levels that rival the 1920s and the Gilded Age. Abandoning the path to shared prosperity appears not only in outsourcing, offshoring, tax inversions, and other headline-grabbing changes, but also in the details of protective labor law. Under the rubric of economic necessity, several states have reduced UI coverage to 12 to 20 weeks from 26 weeks. This comes on top of a long failure to modernize the UI system to address issues of working women and reduced careers. Currently, only 1 in 3 of the unemployed workers receives UI benefits. 2 states have allowed for worker compensation opt-outs, which deprive injured employees of many of the protections they had under state systems. A number of other states are currently considering this. The Supreme Court, in emphasizing the use of private arbitration of employee rights under terms established by the employer, has substantially reduced employees' ability to pursue their legal rights with their employers. Recent steps by the Department of Labor to update the salary standard for employee to be considered exempt is long overdue. Since 1938, DOL and the courts have recognized the single best test of exempt status is a salary high enough to demonstrate that the employee is highly valued. In 1975, an individual who was exempt from the overtime had an annual earning of 110% of U.S. median family earnings. In contrast, at the current level of $455 per week, or $23,660, individuals earning 45% of U.S. median income are exempt. This, if we had a family, one earner, 4 members, this amount, $23,660, would place them below the U.S. poverty threshold. They would be eligible for Medicare, for food stamps, and other income maintenance programs. Current threshold also provides strong incentives for employers to classify low-wage workers as salaried managers and essentially obtain uncompensated work by having them work unpaid overtime. The DOL proposal would just raise the overtime threshold to just below 100% of U.S. median family income. So it would basically not quite restore where it was in 1975. 1975, companies dealt with it successfully, small businesses and large businesses. So I'm not sure that there are going to be disastrous effects. In fact, I'd argue that there would not be disastrous effects. Some brief observations on the gig economy. This is new, this is exciting, this is different. It's not particularly new. Most of my research is on construction, and construction looks a lot like the gig economy. The employee is not tied to a single employer. They regularly move between employers and projects. Because of that gig structure and the lack of a strong relationship between employer and employee, wages fluctuate greatly with immediate demand. There's a lot of economic uncertainty. Benefits such as medical coverage and pensions and 401ks are rare to non-existent. Employer-provided training is also rare to non-existent outside the union sector. Owners and employers regularly complain about a lack of sufficiently skilled craft workers. Southern Power and CURT have been arguing about this for years and trying to find a way to have more trained workers. There is rampant misclassification of employees as independent contractors. As a result, employees are deprived of workers' compensation, unemployment insurance coverage, as well as the employer share of FICA. State and federal governments lose tax revenues. Employers who play by the rules, classify their employees correctly, are substantially disadvantaged in bidding on construction projects. What this suggests is that creating some sort of new structure, independent worker, or something which has reduced benefits, is a problem because it's hard enough to get enforcement of current relatively clear concepts of independent contractor versus employee. You add another status, it becomes virtually impossible. The UI system isn't going to be able to cope with it, and they do most of the misclassification work. To summarize, the proposed revisions of the overtime threshold are in keeping with the history of the Fair Labor Standards Act. It restores that threshold to a reasonable income level. It provides businesses flexibility in employment of highly valuable employees while protecting lower paid employees from being required to work extended hours without compensation. Thank you.
Thank you. Ms. Thomas, we now recognize you for your 5 minutes of testimony.
Good morning. Thank you, Mr. Chairman and members of the House Education and Workforce Subcommittee on Workforce Protections for the opportunity to talk about the proposed changes to the Fair Labor Standards Act. In addition to my role at the University of Michigan, I'm also a member of the National Board and the Public Policy Committee of the College and University Professional Association for Human Resources. It represents human resource leaders at 1,900 U.S. colleges and universities. I know I'm joined by many of my human resource colleagues when I say that I appreciate your willingness to hear and consider the unique impact of these proposed changes on higher education. The University of Michigan supports an increase to the wage threshold, which has not been adjusted since 2004. However, we believe that closing that gap without adequate time for implementation could be counterproductive. Specifically, the new rules call for an increase from the current wage threshold of $23,660 a year to $50,440 a year, with a very short implementation timeline, and outside of the annual budget planning process through which we plan for our new expenses. There are limited ways to raise revenue outside of tuition, so adequate time for planning and implementation is very important. If this change were to occur abruptly, it would be cost prohibitive for schools like Michigan to raise the salaries of those affected to the proposed new minimum in order to maintain the Fair Labor Standards Act exemption status that the workers have today. The University of Michigan is the largest higher ed employer in the state, and these changes would affect more than 3,100 people in roles critical to our missions. The proposed implementation cost at the University of Michigan is as high as $34 million. Early statewide estimates from the Michigan Association of State Universities total more than $60 million for 11 of the 15 member institutions reporting. If salaries were raised just for those employees close to the threshold, most of the remaining affected employees would need reclassification to non-exempt status. Since many jobs in higher education, healthcare, and research are not well suited for hourly compensation, the change would result in reduced autonomy, fewer flexible work arrangements, and diminished opportunities for needed business travel for these employees. Benefits could also be affected when tied to the exemption status. In some institutions, differentials in professional development funding, tuition assistance are also in play. Reclassifying them to non-exempt Fair Labor Standards Act status could represent a loss of total compensation for some employees, with greater complexity for their employers. Additional consequences include reducing opportunities for part-time employment, including roles that involve business event planning and on-site administration, in which staff work longer hours for a limited number of days or weeks in exchange for reduced work hours in subsequent weeks. This serves a business need for our university, but would no longer be possible. University research activities could also be inhibited. Agencies providing research grants, like the National Institutes of Health, often set stipends for postdoctoral researchers well below this new threshold. Since research often requires extended attention to experiments at various times and outside of regular hours, postdocs are not compatible, their roles are not compatible with the new rule. I want to reiterate that we do support an increase to the wage threshold. What we suggest are changes in the way in which an increase is implemented. First, considering lowering the threshold so that the immediate goal is reduced, or differentiate that for economic sectors by establishing a separate threshold for organizations in the nonprofit and public sectors. In either case, the University of Michigan advocates for a phased implementation over years to allow for proper planning. Second, if a more measured approach to increasing the threshold is not adopted, we believe the Department of Labor should consider broadening the existing teaching exemption to include additional positions that are unique to higher education. That means recognizing exemption status in the regulations for not only those who teach and tutor, but for those who advise students, conduct scientific or professional research, provide student counseling, and offer services for residential life. Third, we support a periodic review tied to the cost of living and to occur not more frequently than every 5 years, with at least 1 year notice period to employers of pending increases for planning purposes outlined previously. Finally, unrelated to the wage threshold itself, we believe that any changes to the duties test for exemption should be made available to the community of employers for review and comment before enactment. Thank you.
Thank you, Ms. Thomas. Mr. Wilson, I recognize you for your testimony.
Chairman Wahlberg, Congressman Bishop, thank you for the opportunity to discuss the 21st century workforce and how current rules and regulations affect innovation and flexibility in today's workplaces. Perhaps the best illustration of how the FLSA has failed to keep up with the rapidly evolving workplace is its computer professional provision. Much like the discussion we're seeing now with the gig economy and the sharing economy, in 1990, Congress directed the Department of Labor to publish regulations to treat computer employees as exempt under the FLSA. But then in 1996, Congress froze the regulatory definition of computer professionals in place when less than 40% of Americans owned a cell phone, less than 3% of U.S. homes had broadband access, and Facebook didn't even exist. Today, over 90% of Americans own smartphones. Over 70% of households have broadband. Needless to say, the FLSA rules for computer professionals are woefully outdated. Even in the most traditional industries have undergone dramatic transformations in how and where work is done. For example, workers in old coal power plants were typically divided into several different job categories, with many performing largely physical tasks throughout the plant. Today, newer power plants are run almost entirely by a small group of employees working primarily in one single room filled with computers. The employees are multi-skilled, technically educated, highly paid professionals who take on a variety of duties ranging from operating equipment to handling purchasing, documentation, scheduling, and working with vendors. Yet despite all these changes within the American workplace, during the last half century, the basic structure of the FLSA has never been fundamentally re-examined. It is increasingly having a negative impact on workplace flexibility and innovation. The preference of today's workforce for greater flexibility as to when and where they perform their work is universally acknowledged. And it goes without saying that the desire is often possible only through the digital technology that was unavailable when the FLSA was enacted. In fact, the overwhelming majority of today's employees embrace the digital workplace. A recent Gallup poll showed that full-time employees are upbeat about using their computers and mobile devices to stay connected to the workplace outside their normal work hours. Nearly 8 in 10 workers view this as somewhat or strongly positive development. According to Gallup, nearly all workers say they have access to the internet based on at least one device, and they appreciate the freedom this technology offers them to meet their family needs, knowing they can monitor their email while out of the office, or log in later to catch up with work if needed. Yet the FLSA deters and often prevents an employer from providing this flexibility to non-exempt employees by requiring employers to track all hours worked, which poses a challenge if the employees wish to perform some or all of their duties away from the workplace. Even when non-exempt employees confine their work activities to within normal working hours, they may occasionally check their smartphones outside of those hours of work for work-related emails and meeting invitations. When they do, it raises questions as to whether the time is counted towards hours worked. And some attorneys have argued that such activity could also mark the beginning and ending of the workday, requiring time spent commuting to be also counted as time worked. Because of these challenges and the potential threat of litigation, many employers have taken steps to prevent their non-exempt employees from doing any work outside the workplace by denying them employer-provided smartphones and denying access to their email accounts and other parts of the company's information systems. Regrettably, this inability to take advantage of the virtual workplace inconveniences employees, reduces workplace flexibility, and makes it more difficult for employees to manage their work-life balance. But large employers simply cannot risk exposing themselves to potentially multi-million-dollar class action lawsuits. And the number of lawsuits has exploded over the past 15 years, increasing almost 450% from 2000 to 2015. FLSA also restricts training opportunities. At the time when upgrading the skills of the American workers is a priority, the FLSA's regulations discourage employers from offering training to their employees. Since many training opportunities are considered compensable time under the FLSA, and where training could put a non-exempt employee into an overtime situation, their access to that training may be limited. Non-exempt employees may also be routinely excluded from off-site meetings and trips that could be both beneficial to them and their employer. Because of the administrative difficulty of determining what time is compensable and the actual cost of that time, this inability to participate in off-hours or off-site events can stunt the career growth of non-exempt employees who lose the benefit of those activities. In conclusion, the disconnect between the FLSA and the modern workplace will continue to grow if the law is left unchanged. It will increase tensions among employers, employees, and regulators, with the only true beneficiary being the plaintiff's bar. Congressional attempts at incremental reforms have stalled in the 1990s, and many policymakers are reluctant to make another attempt for political reasons. Yet the pressure to update the FLSA will steadily increase, and it will become a problem that is increasingly more difficult to ignore. Thank you for the time, and I'd be happy to answer any questions you might have.
Thank you, Mr. Wilson, and thanks to the panel. You've laid the foundations here for our discussions, and now I recognize Mr. Bishop for his 5 minutes of questioning.
Thank you, Mr. Chairman. So many questions, so little time. Mr. Wilson, since you just finished, I'd like to ask you a follow-up question on your statement. Can you give us some indication as to how your members are preparing for this rule change now? How is it impacting that environment now?
They're looking at their workforces. They're trying to determine what impact a salary level threshold of around $50,000 would have on their employees in terms of which employees would have to be reclassified as non-exempt. They're looking at the hours that those employees typically are performing, or their duties that they're performing, to see if they're reviewing their duties more carefully, concurrent duties. There's a number of things that they're doing to take into account to make sure that they're complying as best they can with the vague and somewhat ambiguous duties tests that surround the executive and professional and managerial administrative duties exemptions. And they're trying to get a gauge as to what impact it's going to have on their company and the training that they can provide, the types of benefits that they can provide. As was mentioned, some of the benefits and bonuses are structured, their compensation systems are structured in such a way that some of the bonuses are much easier to provide to salaried employees as opposed to paid hourly.
So employers are bracing for impact right now.
Correct.
The impact is potential, but they still have to prepare for it. What kind of impact does that have on their behavior as an employer? Do they freeze their hiring process? Do they freeze any kind of movement within their company, such as maybe even promotions, or any movement within their salaried employees?
That's a great question. I haven't seen that amongst our members yet. They're hiring where hiring is needed and necessary. Mm-hmm. To the degree that it is having an impact on hiring, I would say that it's pulling resources devoted to reviewing and analyzing how they may implement this rule when it becomes final, given the short time frame that they're expected to have between when the final rule comes out and when they have to actually comply with it. The amount of time and effort that's being put into that is actually reducing their ability to hire and extend hours for current employees.
There's so much to ask there. I'd like to spend more time with you, but we're a very small amount of time, and I'd like to move on to Ms. Thomas, if I could, please. You indicated in your testimony that it would cost the University of Michigan $34 million to comply with this rule. That's what you suggested the cost is going to be. In fact, it's $60 million for all of the other universities together, the cost to implement this rule. I can't imagine, I know it's difficult for the University of Michigan and Michigan State University to absorb that kind of cost, but I can't imagine how a smaller university, an Olivet or an Albion or some of these other universities will absorb that cost. My question to you is, we already see skyrocketing costs of tuition in this country. Is this going to impact the tuition? Will this be passed on to the student?
It's inconceivable to me that it would not impact tuition.
So we can see this rule. This is, to me, the ultimate in the law of unintended consequences. This proposed rule has put into place something that's inconceivable to me, that we would change public policy that would actually have that kind of impact on students who already see skyrocketing costs of tuition. And on top of that, skyrocketing costs with their financing and their debt ratio. And these are the very people that are least likely to be employed right now. Which leads me to Mr. Meyer. Your testimony to me is most impactful because you represent the future of our country. And this whole discussion about the gig economy and the shared economy, and talking about Airbnb and Uber and Lyft was never even contemplated back in the 60s and 70s when Governor Romney was around, or Richard Nixon. So we have got to somehow fashion law to comply with today's world. And technology has taken us in a different direction. There are too many things for you to talk about here, I know, because your head's about to explode about how this could impact the people in your world, your millennials. Could you share with us a little bit about this economy, what folks your age are doing? I know that they're engaged in all kinds of online activity, part-time activity. Does this deter them from their future, from gainful employment, from making a future for themselves?
Well, just to speak on the overtime rule, which I didn't touch on in my testimony, but I've looked at, I know for me personally, when I started working at the Manhattan Institute, I was making under what the threshold would be. But I was able to put in many hours. I was able to travel to conferences and do all of this to work up from a research assistant to fellow. If this rule was in place, I would not be a fellow at the Manhattan Institute right now.
Is it possible that the law ever contemplated the idea that we would have smartphones one day or internet connections where we could work from anywhere? I sit in an airport all the time. I'm working my smartphone, responding. I'm typing emails to clearly his work. But did the law ever contemplate? And do you think that the intent of Congress was to somehow grab all of these different things that we do as part of our job?
You can definitively say that the law did not foresee all the changes we've had in the workplace. So what I would like to see is moving forward, realize that these new opportunities, in addition to the sharing economy, it's working on your own, it's working on extra hours, it's working on your smartphone at the airport, that the law doesn't constrain this. Workers are choosing to do this, to advance their careers or to work part-time. We need to get rid of the antiquated notion that it's a master-servant relationship, which was the language used in the 1930s to describe employer-employees. It's not how it is anymore.
The gentleman's time has expired, but we'll have other opportunities. You and I control this process right now. But we're going to try to keep some semblance, I guess, here of our normalcy. Dr. Bellman, going back to the issue of the exempt status and the system by which, or the formula that was put in place back in 1975, 2004, 5, using that formula, would that bring us to the $53,000?
That would actually put us up above the $50,000. In 1975, the threshold was at 110% of U.S. family median income. The reset has left it slightly below 100%. So the answer is it would be higher.
With the 2005 standard?
No, the 2005 standard was at around 53% of U.S. median family income.
Mr. Wilson, coming from your background in dealing with that, give me some background on the reason and the rationality for the 2005 standard in placing it at the 23,000 level, which I think arguably we could say is too low for now.
Yes.
But where would it be now if you used that standard in the formula again?
Well, the history of the Department of Labor in setting the salary level threshold was from 1938 to 1975 was typically they set it at about the 10% of the salaried employees, the 10th percentile of the salaried employees in the United States, roughly in that
Of the total-
at that level. Of all salaried employees, it came in at about the 10% level. In 1975, the decision was made to preliminarily, and it was supposed to be only on an interim basis, adjusted for inflation, which hasn't been done since, and it was raised. In 2004, we took a look at the number of the salaried employees in the United States and took by industry and region, and determined that the best place to set it at was the 20th percentile. We went a little bit higher than it had been traditionally been done. We didn't adjust it for inflation, but we set it at the 20th percentile, taking into account the impact it would have on small businesses, on retail industries, particularly in rural areas, which is critically important in terms of the impact it would have, because it was a relatively large increase at that point in time.
Different than New York or San Francisco.
Exactly, right. And so that's where the Department of Labor set, that's the methodology we used in 2004. Using that methodology today would, off the top of my head, set it at around $35,000 to $40,000 a year in terms of the salary level threshold instead of the $50,000 that's currently being proposed.
Significant less impact, but still, would you say?
A substantial but significantly less impact, yes, in terms of the unintended consequences that would have. And I would also add, Congressman Bishop, that our members are large members, and so they have the ability to adapt to this regulation much easier than a lot of the smaller businesses do. They're for-profit companies as opposed to universities that have much tighter budgets, and they're more easier, can more easily increase the prices of their goods, which to the extent there's an impact on the costs of the bottom lines for our employers and our HR Policies Association members, it'll just be passed on to consumers.
Ms. McKee, you discussed in your testimony the overtime regulation proposed by the Obama administration and its potential impact on employee morale, which is an important issue, especially from the testimony you heard from Mr. Meyer about millennials as well. The proposed regulation would convert many current management employees into hourly employees, even though many employees prefer to be in the exempt classification. What do you see as the biggest concern for employees who are exempt now but would likely be reclassified as non-exempt?
Their largest concern, as articulated to me, is the loss of flexibility in setting their work hours and accommodating work-life balance. We use very minimal overtime at MHA, and I've been proud to be able to work with new generations of employees in order to put together schedules that allow them to meet their priorities. And I have 8 employees on our association side who I will have to demote and reclassify if this law goes through the way it is.
Demote is the appropriate term?
Obviously, Dr. Bellman disagrees with me, but if you ask my 8 employees whether moving from exempt status to non-exempt status was a demotion, they would tell you yes. And they would be in different bonus pools, and they would be in different benefit programs than they were as exempt employees. I don't have employees coming to me and asking to work more overtime. I have employees coming to me to ask for help in putting together a flexible schedule that accommodates their life balance needs.
Okay. My time has expired. I now recognize for a second round Representative Bishop.
Thank you, Mr. Chairman. And just to follow up, Ms. McKee, so this rule on overtime and expanded overtime eligibility will not necessarily result in a windfall of overtime income for newly classified non-exempt employees. Is that correct?
That is correct.
And what is, you see demotions and changes in the characterization of their work, maybe what they do, what other impact does it have? I mean, other than, I think the idea is that, again, I'm trying to get to the reason for the rule. Mr. Meyer said it makes no sense. I grabbed that quote, and I think that best illustrates how I feel about what I'm hearing. But what's the reasoning behind it? We are not going to see an increase in pay. I know that's what the intent, I think, is to try and increase pay and to grab whatever time employees spend working, but the overall net effect is not that at all.
I would agree with you that that is the overall net effect. You asked an interesting question, I thought, earlier also, and I'm in the position of having so much to say with so little time. But you asked what we were doing to get ready for this rule, because we anticipate, of course, a very quick turnaround on that. SHRM established a 6-step process that they recommended all of us follow to become prepared for this. And that ranges from identifying which jobs right now would fall under these thresholds, whether we have a zone within those thresholds where the people who are close to the threshold will receive increases, or whether we'll actually move some people down, what we do with their training opportunities. And this is without discussing the changes that will occur due to wage compression when we move these employees up as well. So there'll be changes to job duties and to schedules and perhaps to staffing levels. You also asked a question about the percentiles, and we did take a look at that because past administrations, both Republican and Democratic, have taken a look at this, and the proposals were between 10 and 20%. At the 30th percentile, the wage would move to $40,196. At the 35th percentile, it would be $44,304. And this proposed threshold, of course, is $50,440. I have 8 employees at this threshold who would be impacted by that. And I love working with my millennial employees. I realize that might sound odd to other HR professionals, but I mean, the whole concept of a gig economy is something that's on my mind. I have people like Mr. Meyer on my staff I want to keep working in jobs that didn't exist when I came to work for the Hospital Association 12 years ago. And this is the kind of give and take I need in order to keep them.
I agree. Mr. Meyer, that was directed at you, and I would agree that much of this is about you and your millennial generation. The unemployment rate is high for your area of the workforce, and we ought to be doing everything we can to encourage growth in employment in that sector of the economy. And while in this case, we live in a world where I'm looking at a statistic here where only 3.6% of private businesses are at least partially owned by some under the age of 30, the lowest proportion in the last 25 years.
Ever since the data began being collected, it's at its lowest level.
So how do is this a direct reflection of how we are interpreting the law and how we failed to accommodate this generation into our workforce?
I think to stay with the focus of this hearing, I'll look at the overtime rule, but imagine a startup. No one, even experienced people at startups, aren't making $50,000 a year. And anyone who's worked there, I know I worked at a startup in college, you're working much more than 40 hours a week. So you're doing it for equity, or you're doing it because it's something you really love and you're investing in this company. So you're not doing it for the salary, and you want to put in those extra hours to make your product work so it can come to market. Putting in this threshold, which really would be prohibitive for startups. Again, telecommuting, all these things that now you would need to keep track of workers' hours when most young people, I'd say the vast majority, want to work from home at least some days a week, work while they're on the road, do all that. It's, again, some large businesses, it's going to create a lot of confusion and some shakeups in their pay, but this is going to really negatively affect startups.
Thank you.
Recognize myself for 5 minutes. It's getting to be a pattern. Work here. Ms. Thomas, you mentioned employees who advise students, who provide counseling and offer services in residential life. How would the services provided to students be affected by the proposed change in the overtime rule?
There are a number of ways where that effect would be realized. Under our current application of the duties test, we have employees that make above and below the proposed threshold, providing services to students. When you want to serve students well, you want to be available when students are available. And so you have flexibility in your workforce regarding being available for counseling and supporting students when they're likely to come to you for
Could
services.
be around the clock, couldn't it?
It could be around the clock, but we don't expect anyone to work around the clock. We want them to be flexible, to be available to their students, and to be available when the student is most likely to seek that assistance. Some is going to be during the day, some is going to be at the end of the day, some is going to be well into the evening as it relates to residential life.
When you take in consideration, especially in the counseling area, whether it's guidance counseling for careers or whether it be mental health guidance counseling that goes on a major university campus like your own, the relationship means a lot. And so while you can program certain hours to be effective in working, generally speaking, with student body, there are times when you can't. Have you costed out or considered the impact financially to the institution to care for those type of needs where the student wants to have that relationship, and that is important for carrying on the counseling aspect by the employee to the student?
I believe that would be very difficult to cost out because across the University of Michigan, as well as the other universities in our country, we are driven to serve students to the very best of our ability. They're part of the reason why we exist, if not the major reason why we exist. And so individuals have the flexibility to be responsive in creating that relationship and sustaining that relationship. in not only student life, but in the academic affairs counseling that our students need to receive.
Well, going away from the purpose and the function, just to the hard, cold facts of the dollars, you indicated in your testimony there could be reductions, significant reductions in pay level, salary level, wages. Could you elaborate further on that?
I think in order to ensure that we have the resources because of our federal grants process and the various stipulations for that, we would not be able to employ as many individuals as we currently do and meet the requirements of the regulations as proposed. So the instance of, we have a number of postdoctoral researchers, we have a number of individuals that work part-time in order to serve the needs of our experiments and our research arena, with less funds available to pay them because of the requirement to maintain their exempt status in order to do their work, we will employ less people in those areas.
Are postdoctoral, they're considered professionals?
They are considered professionals today,
Okay.
and not all of them make above the proposed threshold.
Okay.
In fact, most don't.
Dr. Bellman, it seems to me that reclassifying from exempt salaried status to non-exempt hourly status, as proposed in the overtime rule, would cause a number of problems. As Ms. Thomas notes, this would result in reduced autonomy, fewer flexible work arrangements that employees prefer, and fewer opportunities for business travel. The subcommittee has also received testimony that reclassifying employees from salaried to hourly would cause significant morale problems for employees who would see this as a demotion. Do you agree that more than doubling the salary threshold would have some negative impacts on employees?
I'm sure there'll be employees who believe they've been negatively impacted. However,
If you could pull yourself closer to the mic.
I'm sorry. I'm sure there are some employees who will feel themselves being negatively impacted. However, under this requirement, although they legally move from exempt to non-exempt status, that doesn't mean they have to move from salary to hourly. They can retain that. They can retain all the benefits which they currently have. They can get the same travel and so on. Our problem is this. Essentially, once someone has moved into exempt status, and they could be in exempt status at low incomes. Oh, by the way, this is quite different when you use a 10% or 20% or whatever the salary and say, well, this is way too high. Of course, we have many more salaried workers today in a sense, and much than we did, let's say, in 1975 in the following sense. 1975, there were very few people at fast food restaurants who were considered managerial and therefore exempt. Now this is a way.
But that's all changing.
What?
That's all changing since the 1938, almost 80 years ago.
Right, but I'm saying that while your witnesses are claiming there have been huge changes in the economy, they go back and act as if who is considered salary is identical to what it was in 1975, and that's changed. People at much lower levels of education, at much lower pay levels, get classified as salary in part to avoid paying overtime. So what I'd say is there will no doubt be problems in adjusting to this, as there are with all these rules. We hear the same thing. Minimum wage, it's going to be disastrous if you raise it. Turns out from lots of research, and my most recent book from Upjohn, What Does the Minimum Wage Do?, suggests that the employment effects are de minimis.
Well,
so what I would say is
we'll look forward to taking my time.
We tend to.
My time has expired here, and we'll have further opportunity to discuss that.
Oh,
I
good.
know this is the key issue that we're facing here, dealing with a 1938 law trying to be applied and upgraded in ways that are challenging, to say the least, and difference of opinion on that.
We deal with the
how you make it work
Constitution, which
today.
is over 200 years old. We seem to do okay.
I'll hold myself back on that one. We'll have a chance to talk about that later on after the hearing. I yield now to my colleague, Mr. Bishop.
No, I won't. I want to engage that one. To me, and the world out there reacts to laws and the changes in laws. It does not react well when you have a bunch of unaccountable, unelected boards and departments and agencies promulgating rules that have dramatic impact, that may in fact even change long-existing law and precedent. This is the concern that we have when we do have opportunity to address issues that impact current law and the Constitution, but we do so through Article 1 of the Constitution, which has to do with Congress and the right of Congress, which has exclusive jurisdiction over the passage of laws. Are you concerned at all, Dr. Bellman, that departments and these unelected boards have so much authority to make such a dramatic change in the way we operate in our daily workplace?
I first have to admit, I was born inside the Beltway before there was a Beltway, so I may be biased.
That explains that.
Yes, absolutely. I would say that they're actually fairly substantial procedures to make sure that administrative rulemaking is reasonable, and if it appears not to be reasonable, parties who are concerned can sue to have those procedures overturned. So we have a pretty elaborate system of due process to address these things. I do not see, in my own view, that most of the regulations I see are terribly unreasonable. There are parties who are negatively affected by them, just as there are parties who are positively effective.
Can I ask you a question right there?
What?
Can I ask you a question right there? Because I don't have a lot of time.
Okay, go
I want to
ahead.
capture that thought, because you've got 4 people around you that have raised some really serious concerns, and we've heard dramatic stories of impact. So, and this is not coming from Congress, this is coming from these agencies and departments and Department of Labor, and specifically here, changing law overnight, that has dramatic impact. So our concern is how we change that we can collect this information before and go back to the old way, the way the Constitution intended it to be, where we actually publicly discuss this, we debate it, and we vote on it. And that's the process that we once knew, but now we have a different process. And it's creating havoc at every level of government, every level of business. And that's the problem that we have. And that's what's created this, and that's why the good chairman is walking the earth here, taking us with him to address this issue. So
I would have to say that I respectfully disagree about the process. First of all, this isn't overnight. We have a fairly long, slow procedure for making.
But you heard from Dr.
rules.
Wilson that
And secondly,
it
I would say
immediately impacts people because of the suggestion that it could go into effect. You
would
as a
you
business
agree
owner,
that you have hand-chosen witnesses here, 20% of whom are speaking in favor of the rule? If we had a representative group, because squeaky wheel gets the grease, you want testimony which is favorable to your point of view. You've got testimony which is dependably favorable.
I'm
to your
engaging
point
you
of view.
right now. That's why. And
What?
I'm engaging you right now.
Okay.
Mr. Bellman, this is the normal process,
I agree
regardless
with that.
who's in the majority.
I-
So it's what we deal with. We're delighted to have you here. You're invited here, and you're
I'm
holding your end
delighted to
of
be
the
here.
bargain.
I just want the record to
if I-
reflect
Bishop.
that I like Mr. Bellman, and I like his input, because I think it really, you provide a necessary part of this conversation. We need to know where this is coming from, and the other side of this. So your testimony is very important. My concern is for members of Mr. Wilson's organization, or these other folks out there, and maybe people in the audience today who are directly impacted, even by the suggestion of a rule. It causes a freezing effect for employers out there when rules like this get passed. And I may be wrong, Mr. Wilson, but that has a really serious impact on the economy.
It can. I would just add, in terms of Dr. Bellman's characterization, that there's an administrative procedure here in terms of how rules are proposed and published as final, that works well in this particular area. I would argue that in the case of the proposed overtime rule, that there's a really big problem with that. And that is the request for comments on potential changes to the duties test. They didn't propose specific language that the public could respond to in terms of this is how we're going to change the duties tests, which are very vague, somewhat subjective, somewhat arcane, certainly dated when it comes to the computer professionals. They didn't propose anything. They just asked a series of questions and said, so what do you think we should do with the duties test? The problem is that they didn't, by not proposing any specific thing, the employers have no idea of what the final rule is going to look like. And there's some serious unintended consequences. Just the misplacement of a comma in the duties test for managerial or executive employees can have a significant impact on litigation. And so without publishing specific proposals, they're sort of circumventing the traditional Administrative Procedures Act here and getting around it, which is of great concern to, I think, all employers that are out there.
Gentlemen's time has expired. Mine has come back. Let me carry on with Mr. Wilson on that train of thought. I'd like to get your feedback on the wage and hour division's change in its method of providing guidance. The Obama administration made a decision to provide a so-called, and I quote, administrator interpretations to assist in clarifying the law as it relates to an entire industry, a category of employers. To quote from the Department of Labor's website, they say the Wage and Hour Division believes that this will be a much more efficient and productive use of resources than attempting to provide definitive opinion letters in response to fact-specific requests submitted by individuals and organizations, where a slight difference in the assumed facts may result in a different outcome, end quote. Although opinion letters had been issued previously for decades, the administration decided it would self-select issues and make broad policy pronouncements. Has the Department of Labor frequently utilized administrative interpretations under FLSA to provide clarification to employers, and what impact has that had?
No, it has not. It's new. The administrator interpretive letters is new to this current administration. They suspended actually issuing opinion letters, which are authorized under the Fair Labor Standards Act. And the administrator interpretive letters are more akin actually to regulations that don't go through notice and public comment. And it's hard to say what deference these interpretation letters will get in the courts in the future. And there's always the threat, by not going through notice and public comment, that there's always the possibility that a future administration could simply rescind the interpretive letter, and you end up with a law that goes back and forth, or the rules and regulations that ping-pong back and forth over a course of 4 or 8 years, which is really no way to run a government, let alone try to set the rules for an economy.
Doesn't provide uncertainty.
No, it certainly doesn't, and that's what employers are really desperate for at this point in time.
Mr. Meyer, while the Department of Labor seems intent on making it more difficult for workers to participate in the sharing economy, I'd like to discuss what Congress might do to make it easier for these workers. According to your testimony, many of these workers would like portable benefits, such as health costs and retirement savings. However, if a sharing economy firms were to offer much benefits, this might endanger the independent contractor status of online users. What could Congress do that would assist in spurring on this sharing economy and encourage the benefits that are necessary and wanted as opposed to one size fits all?
Well, there was actually a letter signed by the CEOs of over 30 sharing economy companies bringing up that portable benefits are something they want to provide to their workers because, again, this work is transient. It's done in addition to other work, but hey, some workers really want this. And in the sharing economy, just as any other part of the economy, you have to compete for the best workers. And if you can't get them, your company is not going to succeed. But the more they offer, the more they start to resemble employers under the law. And there's really no trust with the Department of Labor right now because they can just, through a blog post, decide that one of the 6 criteria for determining if someone's an employee doesn't matter anymore. So they don't have really any trust in the Department of Labor, and they're worried that if they start giving workers access to these benefits that they want, while workers don't want all the wage and hour protections, something that comes up over and over again is the portable benefits. If they start doing that, next thing you know, they could be liable for providing all the wage and hour benefits.
With no choice, and intermediate, what does it do to the intermediaries?
So what it would do for the intermediary is completely destroy their business model. I mean, you could imagine an Uber driver signing onto the app and just sitting in the car getting paid minimum wage while they're also driving with another phone for Lyft. I mean, it's actually impossible. Alan Kruger, the Princeton University professor, he released a paper where he agrees with me on all the wage and hour, that these are completely inapplicable. We disagree over the collective bargaining and some of the other protections, but wage and hour, it's really uncontroversial that these do not apply to
stifles.
intermediaries. Yes, it would destroy the sharing economy.
Okay. Mr. Bishop, I yield to you.
Thank you, sir. I wanted to pick up with Ms. Thomas on a question that you asked earlier. You indicated that that your postdocs and research fellows consider themselves professionals. They are considered professionals. Do they consider themselves professionals?
Absolutely.
Sure.
Learned professionals, absolutely.
What would research at U of M? I'm concerned about the research grant system. We have a very important system in place, especially in Michigan with the 3 big research universities. Does this have an impact on the research grant system in our state?
It does have an impact, and how we would conduct the work on an exempt or non-exempt basis in order to conduct the research. The work of a research assistant or associate, the work of a primary researcher, the work of the postdocs who are being trained for higher level work in the academy is not subject to a 40-hour week. All of the nature of that work is performed as described by the researcher, by the grant itself, by the level of experimentation that they're doing. And so to impose non-exempt standards of hourly reporting, it's just incompatible with the work of research.
What's the net effect?
The net effect, as we are predicting, because, for instance, the NIH sets our stipend level, which is below the proposed threshold, would be the employment of fewer individuals in this area in order to ensure that they could remain exempt.
Mr. Chairman, I don't know how long you'd like us to go, but I'm prepared to wrap up if you are.
Well, I'm prepared to ask a few more questions.
Okay. So I will yield back to you then.
Okay. Thank you. I appreciate that. I'm just reveling in the fact of having more than 5 minutes of questioning. And that's nothing on my Chairman Klein, who was with you yesterday. That's just the rules of the process and the time frame. But here we have a little bit more time, and I know you have a meeting to go to following, as do I. But while we have these people here, I'd certainly like to ask a few more questions on my own. Ms. McKee, your written testimony highlights how FLSA hampers employers in their ability to provide workers with greater flexibility, and yet employees are increasingly demanding greater flexibility and control over how, when, and even why they work. That's something, Mr. Meyer, I've been impressed with learning more about the millennial. There is a why to why you work, beyond simply to put food on the table, to care for my family. There are soft values that really are important and that we ought to be considering. But back to Ms. McKee here. The law's prohibition on use of comp time, for instance, in the private sector is one example of how the law curtails flexibility. Are there legitimate reasons for treating the public sector and the private sector differently in this regard?
Not in my opinion. We're competing for the same employees, often in the same field of knowledge. It puts us on an uneven footing.
So you could use comp time very well.
I would argue I could use compensatory time off perhaps more efficiently than the public sector could.
Dr. Bellman, let me just turn to you to give you the opportunity to answer that as well. Is there difference in public and private sector employees relative to things like this, compensatory time as being part of the benefits that would be offered?
I would say that allowing compensatory time for public employees was very specifically done because at the time, they had not had Fair Labor Standards coverage. And so as a result, this was partially an adjustment to the concept that they were sovereign, that this was an extension of protections into a sector where it hadn't existed, and particularly the issue driving this was public safety employees who worked irregular hours, who potentially worked, firefighters and so on, very long hours in a given week. So in my view, two issues. One, public sector, different, and there's a reason why the extension of Fair Labor Standards into the public sector came with comp time. The other thing which I would point to is it becomes almost unenforceable. You know, public sector, we can be reasonably sure that they keep good payroll records and that they're very thoughtful about this, particularly in public safety. Private sector, a lot harder. I'm not saying that any particular organization, but from construction, we know that there are a lot of employers who push the limits of the law and perhaps push well over it, so that trying to administer comp time in a system in the private sector would be it would essentially gut the overtime provisions.
Mr. Wilson,
Yes.
there are differences between public and private sector employees, and I think you accurately talked about some of the inception of the idea with public safety. But we have now gone beyond just thinking of safety, but thinking of benefits, thinking of life values, thinking of flexibility for employees. We're thinking of single-parent families. We're thinking of advancement opportunities for females that, frankly, we didn't think about in the past, that we're considering right now, and rightly so. Mr. Wilson, respond to that, then I'll probably come back to Ms. McKee on that issue of the assertion that in the private sector we won't keep the records as well as the public sector.
Well, I would just add in terms of public safety that, you know, in terms of hospitals, you know, the nurses, the technicians, there's a very key public safety component to that, particularly in an emergency situation where comp time could be very useful in that particular industry. So in the sense of, you know, voluntary for both employers and employees, and a comp time arrangement in the private sector would be a beneficial change to the law, and would allow the private sector to have the same flexibility and benefits that the public sector employees currently enjoy. But it's other than that, that's. Am I going to go back to Mrs. McKee?
Ms. McKee?
I'd like to give you a really clear example on the value of compensatory time off in the private sector. I work with a young woman, a recent hire at MHA, who works in our Human Resources Department. She was trained and educated very, very well at Michigan State University in the Broad School. I have a great deal of regard for Dr. Bellman's work. So she's come to work with us. She worked with us first as an intern, then as a fellow, same sort of opportunity Mr. Meyer got. Now she's a full-time regular employee at the MHA. And the last couple of weeks she's been working on closing on her new house, moving. I never have to wonder whether she's putting in the hours that she should put in. And I really don't care if she wants to work 10 hours today and 6 hours tomorrow because she needs to meet with the loan officer. She's the one who put together some of the research behind my testimony today. She's in the audience, Tori Martin, and she is one of the employees that, under these guidelines, I would have to move back to non-exempt status. And it would undermine everything she told me she values about working at MHA. And while I would agree with Dr. Bellman that there are industries that have required greater scrutiny than others, we've worked really hard in the private sector to be an employer of choice. I wouldn't even be affected by these laws if the change had been 30% increase or under, because we try to stay ahead of it and provide these sorts of opportunities. That's what those of us who are involved with SHRM do. What really offends me is legislation like this that starts from the premise that none of us can be trusted to treat our employees correctly.
I would also add that large employers keep very good records, and most employers, nearly all employers. There are some that don't. The Wage and Hour Division, their enforcement is appropriately focused on some of those industries, and where they go out and have directed investigations, and they find that, they take action against those employers that don't keep good records. But the vast majority of employers keep records, primarily for tax purposes, because they have to comply with the IRS. Nobody wants the IRS coming down on them. And also primarily for potential litigation that may ensue. If you're not keeping good records, you're opening yourself up to a litigation that could be very, very costly.
Well, compliance costs today, most recent I've seen is about $1.9 trillion to businesses for just compliance white paper costs of regulatory issues. So, Dr. Bellman,
So you're ready.
My answer to that is Walmart, the largest employer in the U.S., maybe was involved in a few wage and hour violations. Seems to fall exactly into your category, and clearly basically didn't care about that law. So I'm not sure
Well, actually,
what
they did.
large employer.
Walmart actually came to us to help them with what they refer to as their arcane and somewhat outdated bonus structure system. And they came to us, and we worked with them to work out the particular issues that they had between their exempt and their non-exempt employees. We worked it out to a mutual benefit of both the employer and the employees and the federal government, and on a satisfactory basis.
So how did you deal with locking employees into their stores for uncompensated overtime? Did you come up with a policy
That was
for that?
after those alleged violations were after I was out of the Department of Labor, so I can't address those particular issues. I'm just particularly speaking of the wage and hour investigations that we conducted in Walmart back in 2005, 2006, I believe.
Okay, so
I can't address that.
there are certainly bad actors or mistakes, both that take place. Our concern, though, in the governmental entity is making sure that we don't just regulate on the basis of the small number of bad actors or mistakes that take place, but we do something that fosters the growth of those that are doing the right thing for their employees. Let me ask one final question, and I'm glad there are no lights left, so I can ask that final question. And I'm going to go back to Mr. Meyer again. When individuals who provide services through online platforms are deemed to be employees, this can have a number of consequences for both the sharing company, economy company, and the platform users. What has been the experience of sharing economy companies when they have shifted from an independent contractor model to an employee model? And secondly, was this a good thing for the independent contractors?
Well, one company I can speak of, HomeJoy, it actually had to shut.
What was that?
HomeJoy. So think an Uber of house cleaning. You can find someone who's an independent.
Man alive, I'm finding more all the time. Where you guys come up with these ideas?
But so they had to shut down actually over employment classification questions. And the reason for this is the CEO said their labor costs went up about 40%. So their costs, because of added labor costs, increased 40%. And this is right in line with what the Department of Labor's Employment Cost Index shows, which is about a 30% increase to move to classifying as employees. And I just want to point out, when you're working for multiple companies, I mean, I have friends who work for Postmates, work for Uber, and have a full-time job also. So why do you need these other companies then paying for your workers' comp or your unemployment? Like, I could do one ride for Uber this afternoon as a driver, and then not work for 4 months, then do another ride. how does unemployment insurance figure into that? So it just shows that this is a different nature of work where it's really entrepreneurial. You're working for yourself. We can't apply the same standards to a completely different model of work.
Yeah. It was interesting, just last week, I took an Uber ride from my office downtown, and the driver that I had, very articulate. Come to find out, in the course of the conversation, he has 4 degrees, 2 doctoral degrees. And I asked, what in the world are you doing driving Uber? Are you writing a book on experiences? He says, that might be an idea. He said, but no, I'm paying off my student loan debt. So there's an economy there that serves. Well, I appreciate, I don't want to belabor this, getting toward the end of the time, and I know that my colleague has to get to a veterans issue of great importance, and we're going to spend a little more time here in this community college looking at what's going on here. But I'd offer to my colleague any opportunity for any final comments that you'd like to make.
Well, I've had the opportunity to research, to be in the practice of law, to do what I've done over the years and see some of this firsthand for 25 years now. Before I came to Congress, I was in the private sector. I was actually in the compliance officer arena. I was the chief counsel for a small company in the financial world. And we had the opportunity to face many, many compliance issues. And it was very difficult. It was very difficult for us to survive. But the impact on every single law that came down on compliance issues was to freeze what we were doing so that we could assess whether or not we could withstand what the new rule was. We didn't want to stick our neck out too far because we knew, and when I say stick our neck out, meaning we'd like to hire more people, we'd like to expand, but we're not going to until we can figure this whole thing out. And now, Mr. Chairman, we live in a world where it's not government, seated government anymore that's doing this. It's agencies and the departments and different boards of unelected officials who don't face re-election, who don't have to face the re-election process and face ultimately voter accountability. And to me, that's raised all new problems in this country, especially in an economy that's just absolutely handcuffed right now and being choked out, and especially in the small business environment where we see, which is the backbone of our economy. We see small business holding on for life. They want to grow, they want to create jobs, but they just won't do it because this world is too crazy and there's too much government, too much regulation. The rules that we've talked about tonight were created in an environment that did not give the people that really have to live with it the opportunity to weigh in, and they don't make sense. And it's embarrassing to a certain extent for members of Congress to be told that by constituents and by a panel like this and not be able to do a thing about it because we don't have the proper oversight to do so. I'm grateful to you and this committee for bringing these issues forward so that we can discuss them in a public environment and so that we can raise awareness to those that are promulgating these rules as to why rules like this should be given more consideration, more vetting, more public debate, because in the end, we're seeing more of the unintended consequences than we are of the actual intent of whatever the promulgating organization is that put the rule forward. So I'm grateful for what you've provided us today, the time and those that have weighed in on this subject. Thank you all for your testimony. I'm hoping that in the future that Congress will have the opportunity to address this in a meaningful way so that we can bring a sense of calm and clarity to the law, and that we can grow and expand this economy, and that people will get hired and students that are in debt won't have to deal with this anymore, and that maybe one day you and I can work and be Uber drivers.
Always that option, isn't it?
Or HomeJoy too, that sounds like a good idea.
Well, thank you, and thank you to the panel for taking your time to come here. And hope was a little bit except for at least, well, two of you, this was closer to your home site as well, doing it in a field hearing. I, like my colleague here, had a life before Congress, and one of those areas was as a division manager in the Institute of Higher Education, specifically in the area of development. And I had a whole team, a national team, that were salaried, every one of them. And every one of them had flexibility of being away from me most of the time, but doing a great work for the institution in stewardship and providing resources for major projects over the course to the tune of about $35 million over the course of time, projects raised. And that spent a lot of time in the field. They needed flexibility. I can't envision what impact this overtime reg would have on their functioning, which was amazing. The opportunities that they brought forward to students, faculty alike, by their ability to serve the people that would provide the resources for international as well as national projects for this institution. We certainly don't ever want to let it be said that there is a divide in the minds of this committee or Congress on the fact that employers and employees ought to be treated well. We ought to encourage employers to expand, to be more successful, in turn to be able to hire more people, but to take care of the people they have, developing greater opportunities for them. I think that's why we wrestle with a 1938 law, almost 80 years, where it really hasn't been changed all that much. And every time we attempt to go into areas where I think it would foster growth for employees as well as employers, the landmines begin to develop on issues that go no place in extending the successful opportunities for both sides. It becomes partisan, and I've appreciated some of the efforts of issues we've talked with on our subcommittee, and wish we could expand it still further to the full Congress to put aside the partisan politics issues and make sure we upgrade a law that could be very effective to expand the opportunity of this great country, using free enterprise, using the market economy, using the creativity that's developing within our new generations coming forward, with the tools that they have and the flexibility they can make for better life and not hold people back. And so that will continue to be our effort. I would like to think that the bill that I've introduced that would just do one simple thing. Let's look at the economics. How does it truly impact both the employee and the employer, and then find a way whereby we might upgrade the law, but do positive things on both sides of the ledger to make sure that we continue to advance. Any opportunities that we've had to travel internationally on our congressional delegation trips and see the competition that's out there. They're not sitting back. They're aggressively moving forward. We don't have that luxury anymore. In our DNA, we have everything necessary to stay at the head of the pack unless we hold ourselves back. And my contention is that over large bureaucracy, allowed by unlimited government, takes away the unlimited opportunity back in the districts. So I appreciate this hearing today, and thank you for each of you attending. I thank Lansing Community College again for giving us the opportunity for a great facility. And with that, I'll close the hearing. It's adjourned.
Thanks, sir.
Great to meet you. Would love to.